Book Interpretation of Statutes by Chartered Accountants Institute. Interpretation of statutes, deeds and documents is broken down into 5 parts. First, introduction of relevant terms. Second, importance of interpretation of statutes. Third, rules of interpretation. Rules of interpretation are further broken down into 2, primary rules and secondary rules. Then aids to interpretation. Aids to interpretation are broken down into internal aids and external aids. And lastly, rules of interpretation of deeds and documents. Introduction. This study relates to interpretation of statutes, deeds and documents. So first of all, we must understand what these terms and some other terms denote. It would therefore be important for us at this stage itself to understand the terms statute, document, instrument, deed and interpretation. Statute to the common man, the term statute generally means the law and regulations of every sort without considering from which source they emanate. However, the term statute has been defined as the written will of the legislature, solemnly expressed according to the forms necessary to constitute it, the law of the state. Normally, the term denotes the act passed by the legislative authority, Parliament of India or state legislatures. The Constitution does not use the term statute, though one finds the term law used at many places. The term law is defined as including any ordinance, order, bylaw, rule, regulation, notification and the like, because many of them have not come from the statutory authority. They come from other executive authorities to whom subordinate delegation is made. In short, statute signifies written law in contradiction to unwritten law. Document. Generally understood, a document is a paper or other material thing giving information, proof or evidence of anything. The law defines a document in a more technical form. Section 3 of the Indian Evidence Act states that the document means any matter expressed or described upon any substance by means of letters, figures or marks or by more than one of those means intended to be used or which may be used for the purpose of recording that matter. Example, a writing is a document. Any words printed, photographed are documents. Section 3, Clause 18 of the General Clauses Act states that the term document shall include any matter written, expressed or described upon any substance by means of letters, figures or marks, or by more than one of those means which is intended to be used or which may be used for the purpose of recording this matter. Generally, documents comprise the following 4 elements. Elements of a document. 1 is matter, 2nd is record, 3rd is a substance and 4th is a means. Matter. This is the first element in its usage when the word any shows that the definition of a document is comprehensive. Record. The second element must be certain mutual or mechanical device employed in substance. It must be by writing, expression or description. Substance. This is the third element on which the mental or intellectual elements comes to find a permanent form. Means. This represents the fourth element by which such permanent form is acquired, and those can be letters, any figures, marks, symbols which can be used to communicate between the two persons. Instrument. In common parlance, instrument means a formal legal document which creates or confirms a right or records a fact. It is a formal writing of any kind. Such an agreement, deed, charter or record drawn up and executed by a technical form. It also means a formal legal document having legal effect either as creating liability or as affording evidence of it. Section 2, Clause 14 of the Indian Stamp Act 1899 states that the instrument includes every document by which any right or liability is or purports to be created, transferred, extended, extinguished or recorded. Deed. The legal glossary defines deed as an instrument in writing or other legible representation or words on parchment or paper purporting to effect some legal disposition. Simply stated, deeds are instruments, though all instruments may not be deeds. However, in India, no distinction seems to be made between instruments and deeds. Interpretation. By interpretation is meant the process by which courts seek to ascertain the meaning of the legislature through the medium of the authoritative forms in which it is expressed. Simply stated, interpretation is the process by which the real meaning of the act or a document and the intention of the legislature in enacting it or the parties executing the document is ascertained. Interpretation signifies expounding the meaning of abstruse words and writings, making out of their meaning, explaining, understanding them in a specified manner. A person is thereby aided in arguing, contesting, interpreting the proper significance of a section, a proviso, explanation or schedule to an act or any document, deed or instrument. Importance of interpretation. Interpretation thus is a familiar process of considerable significance. In relation to statute law, interpretation is of importance because of the inherent nature of legislation as a source of law. The process of statute making and the process of interpretation of statutes takes place separately from each other, and the two different agencies are concerned. An interpretation of an act serves as a bridge of understanding between the two. Judicial determination of questions of law requires the use of materials of various types. Depending on the nature of the question, in the interpretation of statutory provision, the material used will naturally have a sharply legal character, as distinct from the application of a general common law doctrine where it may have a more diffused character. In statutes, greater accuracy is therefore required. The process of interpretation is more legalistic and makes more intensive use of the legal technique in statutory interpretation, as contrasted with the application of the common law rules. Classification of interpretation. General classification of interpretation into legal and doctrinal. Legal is broken into two, authentic and usual. Under doctrinal, there are two, grammatical and logical. Jolovics, in his lectures on jurisprudence, speaks of the interpretation thus: interpretation is usually set to either legal or doctrinal. It is legal when there is an actual rule of law which binds the judge to place a certain interpretation of the statute. It is doctrinal when its purpose is to discover real and true meaning of a statute. Legal interpretation is subdivided into authentic and usual. It is authentic rule when the rule of interpretation is derived from the legislator himself. It is usual when it comes from some other source such as custom or a case law. Thus, when Justinian ordered that all the difficulties arising out of his legislation should be referred to him for decision, he was providing for authentic interpretation. And so also was the Prussian Code, when it was laid down that the judges should report any doubt as to the meaning to a statute commission and abide by their ruling. Doctrinal interpretation may again be divided into two categories, grammatical and logical. It is a grammatical when the court applies only the ordinary rules of speech for finding out the meaning of the words used in the statute. On the other hand, when the court goes beyond the words and tries to discover the intention of a statute in some other way, then it is said to resort to what is called a logical interpretation. According to Fitzgerald, interpretation is of two kinds: literal and functional. The literal interpretation is that which regards the conclusively the verbal expression of the law. It does not look beyond the literal edges. The duty of the court is to ascertain the intention of the legislature and seek for that intent in every legitimate way, but first of all in the words and language employed. Functional interpretation, on the other hand, is that which departs from the letter of the law and seeks elsewhere or for some other and more satisfactory evidence of the true intention of the legislature. In other words, it is necessary to determine the relative claims of the letters and spirit of the enacted law. In all ordinary cases, the courts must be content to accept the letter of the law as the exclusive and conclusive evidence of the spirit of law. Salmon Jurisprudence. It is essential to determine with accuracy the relations which subsist between the two methods, interpretation and construction. It would also be worthwhile to note that at this stage itself the difference between the terms interpretation and construction. While more often than not the two terms are used interchangeably to denote a process adopted by courts to ascertain the meaning of the legislative form in which it is expressed, these two terms have different connotations. Cardinal rule of construction of a statute is to read it literally, which means by giving to the words used by the legislature their ordinary, natural and grammatical meaning. If such reading leads to absurdity and the words are susceptible of another meaning, the court may adopt the same. If no such alternative construction is possible, the court must adopt the ordinary rules of literal interpretation. Whereas cardinal rule of interpretation is that if the language is simple and unambiguous, it is to be read as is with the clear intention of the legislation. CWT versus Srimati Muthu Zulaika. For the purpose of construction of a statute, the same has to be read as a whole. State of Bihar versus CIT. The difference between interpretation and construction. Interpretation differs from construction. Interpretation is the finding out the true sense of any form, and the construction is the drawing of conclusion respecting the subject that lie beyond the direct expression of the text. Bhagavati Prasad Kedia versus CIT. It is the duty of the courts to give effect to the meaning of an act when the meaning can be equitably gathered from the words used. Words of legal import occurring in a statute which have acquired a definite and precise sense must be understood in that sense. State of Madras versus Gannon Dunkerley. When a legislature uses certain words which have acquired a definite meaning over a period of time, it must be assumed that those words have been used in the same sense. Thus, where the court adheres to the plain meaning of the language used by the legislature, it would be interpretation of the words, but where the meaning is not plain, the court has to decide whether the wording was meant to cover situation before the court. Here the court would be resorting to what is called as construction. However, the two terms interpretation and construction overlap each other and it is rather difficult to state where interpretation ends and construction begins. Why do we need interpretation and construction? No doubt in modern times enacted laws are drafted by legal experts, yet they are expressed in language, and no language is so perfect as to leave no ambiguities. Further, by its very nature, the statute is an edict of the legislature, and many times the intent of the legislature has to be gathered not only from the language but the surrounding circumstances that prevailed at the time when that particular law was enacted. If any provision of the statute is open to two interpretations, the court has to choose the interpretation which represents the true intention of the legislature. Also, it is not within human powers to foresee the manifold sets of facts which may arise in the future, and even if it were so, it is not possible to provide for them in terms of free from all ambiguity. All these aspects add to this great prominence to the subject of interpretation and construction in the practical administration of law. It would be worthwhile to note that Denning has said on the need for statutory interpretation. He said, "It is not within human powers to foresee the manifold sets of facts which may arise, and that even if it were, it is not possible to provide for them in terms of free from all ambiguity. The English language is not an instrument of mathematical precision. Our literature would be much poorer if it were. This is where the draftsmen of the Act of Parliament have often been unfairly criticized. A judge believing himself to be fettered by the supposed rule that he must look to the language and nothing else, laments that the draftsmen have not provided for this or that, or have been guilty of some other ambiguity. It would certainly save the judges the trouble if Acts of Parliament were drafted with divine prescience and perfect clarity. In the absence of it, when a defect appears, a judge cannot simply fold his hands and blame the draftsman. He must set to work on the constitution task of finding the intention of the Parliament, and he must do this not only from the language of the statute, but also from a consideration of the social conditions which gave rise to it, and of the mischief which it was passed to remedy. And then he must supplement the written word so as to give force and life to the intention of legislature. It has been rightly said that the statute is the will of legislature. The fundamental rule of interpretation of statute is that it should be expounded according to the intent of those who made it. In the event of the words of the statute being precise and unambiguous in themselves, it is only just necessary to expound those words in their natural and ordinary sense, thus far and no further. This is because these words distinctly indicate the intention of legislature. The purpose of interpretation is to discern the intention which is conveyed, either expressly or impliedly, by the language used. If the intention is expressed, then the task becomes one of verbal construction alone. But in the absence of any intention being expressed by the statute on the question to which it gives rise, and yet some intention has to be of necessity imputed to the legislature regarding it, then the interpreter has to determine it by inference based on certain legal principles. In such a case, the interpretation has to be the one which is commensurate with public benefit. Consequently, if a statute levies a penalty without expressly mentioning the recipient of the penalty, then by implication it goes to the officers of the state. The subject of the interpretation of a statute, therefore, seems to fall under two general heads. What are the principles which govern the construction of language of an Act of Parliament? 2. What are those principles which guide the interpreter in gathering the intention on those incidental points on which the legislature is necessarily presumed to have entertained an opinion, but on which it has not expressed any? Though the process of interpretation, the court seeks to discern the meaning of the legislation through the medium of authoritative forms in which it is expressed. As we have noted earlier, interpretation may be either grammatical or logical. Grammatical interpretation concerns itself exclusively with the verbal expression of the law. It does not go beyond the letter of the law. Logical interpretation, on the other hand, seeks more satisfactory evidence of the true intention of the legislature. In all ordinary cases, grammatical interpretation is the sole form allowable. The court cannot take from or add to modify the letter of the law. This rule is, however, subject to some expectations. Firstly, where the letter of the law is logically defective on account of ambiguity, inconsistency, or incompleteness. As regards the defect to ambiguity, the court is under a duty to travel beyond the letters of law so as to determine from the other sources the true intention of the legislature. In the case of the statutory expression being defective on account of inconsistency, the court must ascertain the spirit of the law. Secondly, if the text leads to a result which is so unreasonable that it is self-evident that the legislature could not mean what it says, the court may resolve such impasse by inferring logically the intention of the legislature. About one thing there seems to be no controversy at all. A statute is enforceable at law, however unreasonable it may be. The duty of the court is to administer the law as it stands. It is not within its jurisdiction to see whether the law is just or unreasonable. The ascertainment of the justification or reasonableness of the law is exclusive domain of the legislature, and it alone can consider alteration or modification of the law passed by it. Until it is altered or modified or amended, the court has no choice but to enforce the law as it is. In the process of interpretation, several aids are used. They may be statutory or non-statutory. The former category, statutory aids, illustrated by the General Clauses Act and by specific definition contained in the Individual Act, as also by certain provisions of a general nature, which are, for example, contained in the Indian Penal Code and are relevant to the construction of penal enactments. The latter is illustrated by common law rules of interpretation, including certain presumptions relating to interpretation, and also by case law relating to the interpretation of statutes. Process of interpretation. Aids is broken into two: statutory, illustrated by two more, General Clauses Act and specific definitions contained in the Individual Acts. Next, non-statutory, illustrated by one, common law rules of interpretation, and second, case law relating to the interpretation of statutes. Rules of interpretation or construction. Over a period, certain rules of interpretation or construction have come to be well recognized. However, these rules are considered as guides only and are not inflexible. These rules can be broadly classified as follows: primary rules and secondary rules. Primary rules are further divided into rule of literal construction, rule of reasonable construction, rule of harmonious construction, rule of beneficial construction, rule of exceptional construction, and rule of ejusdem generis. Secondary rules are effect of the usage and associated words to be understood in common sense manner. Primary rules. Rule of literal construction. It is the cardinal rule of construction that words, sentences, and phrases of a statute should be read in their ordinary, natural, and grammatical meaning, so that they may have effect in their widest amplitude. At the same time, the elementary rule of construction has to be borne in mind that words and phrases of technical nature are prima facie used in their technical meaning, if they have any, and otherwise in their ordinary popular meaning. When the language of the statute is plain and unambiguous and admits of only one meaning, no question of construction of a statute arises, for the act speaks for itself. The meaning must be collected from the expressed intention of the legislature. Case State of UP versus Vijay Anand. A word which has a definite and clear meaning should be interpreted with that meaning only, irrespective of the consequences. Sometimes occasions may arise when a choice has to be made between two interpretations, one narrower and other wider or bolder. In such a situation, if the narrower interpretation would fail to achieve the manifest purpose of legislation, one should rather adopt the wider one. For example, when we talk of disclosure of the nature of the concern or interest, financial or otherwise, of a director or manager of a company in the subject matter of a proposed motion, we have to interpret in its broader sense that any concern or interest containing any information and facts that may enable members to understand the meaning, scope, and implications of the terms, items of business, and to take decision thereon. What is required is a full and frank disclosure without reservation or suppression. As for instance, where a son or a daughter or a father or a mother or a brother or a sister is concerned in any contract or matter, the shareholders ought to fairly to be informed of it and the material facts disclosed to them. Here, a restricted, narrow interpretation would defeat the very purpose of the disclosure. Further, the phrase and sentences ought to be construed according to the rules of grammar. This was emphasized in no uncertain terms by Supreme Court in the case SS Railway Company versus Workers' Union, when it is stated that the court should give a literal meaning to the language used by the legislature, unless the language is ambiguous or its literal sense gives rise to any anomaly or results in something which may defeat the purpose of the act. It is the duty of the court to give effect to the intent of the legislature, and in so doing, its first reference is to the literal meaning of the words employed. Where the language is plain and admits only of one meaning, there is no room for interpretation, and only that meaning is to be enforced, even though it is absurd or mischievous. The maxim being absoluta sententia expositore non litigat, non indigat, which means a simple proposition needs no expositor. That is, when you have a plain words capable of only one interpretation, no explanation to them is required. Similarly, when a matter which should have been but has been provided for in a statute cannot be supplied by courts, as to do so would amount to legislation and would not be a construction. For example, Section 71 of the UP District Boards Act provided that the board may dismiss its secretary by special resolution, which in certain cases required sanction of the local government. Section 90 of the same Act conferred a power to suspend the secretary by pending inter alia the orders of any authority whose sanction was necessary for his dismissal. Section 71 of the Act was amended in 31, and it then provided that a resolution of a dismissal was not to take effect till the expiry of the period of appeal or till the decision of the appeal, if it was so presented. However, Section 90 of the Act was not correspondingly amended. Supreme Court observed that it was unfortunate that when the legislature came to amend the old Section 71 of the Act, it forgot to amend Section 90 in conformity with the amendment of Section 71. The Court, however, emphasized that while no doubt it is the duty of the Court to try and harmonize the various provisions of the Act passed by legislature, it is certainly not the duty of the Court to stretch the word used by legislature to fill in the gaps and omissions in the provisions of an Act. However, sometimes the courts may look at the setting or the context in which the words are used and the circumstances by which the law has come to be passed to decide whether there is something implicit behind the words actually used, which would control the literal meaning of the words so used. There are two possible constructions of a clause, one a mere mechanical and a literal construction based on the rules of grammar, and the other which emerges from the setting in which the clause appears, and the circumstances in which it came to be enacted, and also from the words used therein. The courts may prefer the second construction, which, though may not be literal, may be a better one. Example, Aurora versus State of UP. Words used in a popular sense. In dealing with matters regarding the general public statute are presumed to use words in their popular sense. But to deal with particular business or transaction, words are presumed to be used in the particular meaning in which they are used and understood in the particular business. However, words in statutes are generally construed in their popular meaning and not in their technical meaning. It is general rule that omissions are not likely to be inferred. From this, it brings another rule that nothing is to be added to or taken away. The rule of beneficial construction or Hayden's rule. Where the language used in a statute is capable of more than one interpretation, the most firmly established rule for construction is the principle laid down in Hayden's case. The rule, which is also known as the purposive construction or a mischief rule, enables the consideration of four matters in construing an act. What was the law before making of the act? What was the mischief or a defect for which the law did not provide? What is the remedy that this particular act had provided? And what is the reason for the remedy? The rule then directs that the courts must adopt the that construction which shall suppress the mischief and advance the remedy. Therefore, even in a case where the usual meaning of a language used falls short of the whole object of the legislature, a more extended meaning may be attributed to the words, provided they are fairly susceptible of it. If, however, the circumstances show that the phraseology in the act is used in a larger sense than its ordinary meaning, then that sense may be given to it. If the object of a statute in public safety, then its working must be interpreted widely to give effect to that object. Thus, the legislature having intended while passing the Workmen's Compensation Act that every workman in the prescribed trade should be entitled to compensation, it was held that the act ought to be so construed as far as possible as to give effect to its primary provision. Statutes which require something to be done. Example, a statute which requires notice of an action for anything done or ought to be construed as including an omission of an act which ought to be done as well as the commission of a wrongful act. Where a statute requires something to be done by a person, it would generally be sufficient compliance with it if the thing is done by another person on his behalf or by his authority, for it would be presumed that the statute does not intend to prevent the application of the general principle of law, qui facit per alium facit per se. He who acts through another is deemed to act in person. That would be so unless there is something in either the language or the object of the statute which shows that the personal act alone was intended. However, it has been emphasized by the Supreme Court that the rule in Hayden's case is applicable only when the words used are ambiguous and are reasonably capable of more than one meaning. Case CIT versus Sodra Devi. Example of application of this mischief rule is also well founded in the construction of Section 2D of the Prize Competition Act. The section defines prize competition as any competition in which prizes are offered for the solution of any puzzle based upon the building up, arrangement, combination or permutation of letters, words or figures. The issue is whether Act applies to competitions which involve substantial skill or are not in the nature of gambling. Supreme Court, after referring to previous state law to the mischief and construed under that Act and on to resolutions of various states under Article 252 Clause 1 authorizing Parliament to pass the Act, it was stated that having regard to the history of the legislation, declared object thereof, and the wording of the statute, We are of the opinion that the competitions which sought to be controlled and regulated by the Act are only those competitions in which a success does not depend on any substantive degree of skill. RMD Chamar Bagwala versus Union of India. The correct principle is that after the words have been construed in that context, it is found that the language is capable of bearing only one construction. The rule in Hayden's case ceases to be controlling and gives way to the plain meaning rule. Lord Semen explains this aspect that Hayden's case is available at two stages. 1. Before ascertaining the plain and primary meaning of the statute. Secondly, at the stage where the court reaches the conclusion that there is no such plain meaning. Rule of exceptional construction. The rule of exceptional construction stands for the elimination of statutes and words in a statute which defeat the real objective of the statute and make no sense. It also stands for construction of words and, or may, shall, and must. This rule has several aspects, namely the common sense rule. Despite the general rule that full effect must be given to every word if no sensible meaning can be fixed to a term, word, or a phrase, or if it would defeat the real object of the enactment, it should be eliminated. The words of a statute must be so construed as to give a sensible meaning to all of them, if at all possible. They ought to be construed ut res magis valeat quam pariat, meaning thereby it is better for a thing to have effect than to be made void. Conjunctive and disjunctive words, or and. The word or is normally disjunctive and is normally conjunctive. However, at times they are read as vice versa and give effect to the manifest intention of the legislature as disclosed by the context. This should be so where the literal reading of the words produces an unintelligible or absurd result. In such a case, and may be read for or and or for and, even though the result of so modifying the words is less favorable to the subject, provided that the intention of the legislature is otherwise quite clear. In the Official Secrets Act, as per Section 7, any person who attempts to commit any offence under the principal act of this Act, or solicits or incites or endeavours to persuade another person to commit an offence, or aids or abets and does any act preparatory to the commission of an offence. Here the word and is in bold, is to be read as or. Reading and as and will result in unintelligible and absurd sense and against the clear intention of the legislature. Case R versus Oaks. Next, may, must and shall. Before discussing the aspect, it would be worthwhile to note the term mandatory and directory. Practically speaking, the distinction between a provision which is mandatory and the one which is directory is that when it is mandatory, it must be strictly observed. When it is directory, it would be sufficient that it is substantially complied with. However, we have to look to the substance and not merely the form. An enactment is mandatory form might substantially be directory, and conversely, a statute in directory form may be in substance be mandatory. Hence, it is substance that counts and must be precedence over mere form. If a provision gives a power coupled with a duty, it is mandatory. Whether it is or not so would depend on such consideration as the nature of the thing empowered to be done, object for which it is done, and the person for whose benefit the power is to be exercised. May. It is well settled that enabling words are construed as compulsory. Wherever the object of the power is to give effect to a legal right, the use of the word may in a statutory provision would not by itself show that provision is directory in nature. In some cases, the legislature may use the word may as a matter of pure conventional courtesy and yet intend a mandatory force. Therefore, in order to interpret the legal import of the word may, we have to consider the various factors. Example, the object and the scheme of the act, the context or background against which the words have been used, the purpose and advantages of the act sought to be achieved by use of the word, and the like. Where the words may involve a discretion coupled with an objection. That is a discretion, The word may is often read as shall or must. When there is something in the nature of a thing to be done, which makes it duty of the person on whom the power is conferred to exercise the power, no general rule can be laid down for deciding whether any particular provision in a statute is mandatory, meaning thereby that the non-observance thereof involves the consequences of invalidity or only directory, that is a discretion. Non-observance of which does not entail the consequences of invalidity, whatever other consequences may occur. But in each case, the court has to decide the legislature's intent. Did the legislature intend in making the statutory provision that non-observance of this word entail invalidity or did it not? To decide this, we have to consider not only the actual words used, but the scheme of the statute, the intended benefit to the public, or what is enjoined by the provisions and the material danger to the public by the contravention of the scheme. The use of the expression shall or may is not decisive. Having regard to the context, the expression may has varying significance. In one context, it may purely permissive, while in another context, it may confer a power and make it obligatory upon the person invested with the power to exercise it as laid down. Therefore, while undoubtedly the word may generally does not mean must or shall, yet the same word may is capable of meaning must or shall in the light of the context in which it occurs. Next, shall. The word shall would not itself make a provision of the act mandatory. It has to be construed with reference to the context in which it is used. Thus, as against the government, the word shall, when used in statute, is to be construed as may, unless a contrary intention is manifest. Hence, a provision in a criminal statute that the offender shall be punished as prescribed in the statute is not necessarily to be taken as against the government to direct the prosecution under what provision, rather than under some other applicable statute. Therefore, generally speaking, when a statute uses the word shall, prima facie it is mandatory, but it is sometimes not so interpreted if the context or intention of the legislature otherwise demands. Thus, under certain circumstances, the expression shall is construed as may, yet it has to be emphasized that the term shall, in its ordinary significance, is mandatory, and the court shall ordinarily given that interpretation to the term. Unless such an interpretation leads to some absurd or inconvenient consequence, or be at variance with the intent of the legislature to be corrected from other parts of the act. For ascertaining the real intention of the legislature, the court may consider, amongst other things, the nature and design of statute, the consequence which would flow from construing it one way or the other, the impact of other provisions by resorting to which the necessity of complying with the provisions in question can be avoided, whether or not the statute provides any penalty if the provision in question is not complied with. If the provision in question is not complied with, whether the consequences will be trivial or serious. And most important of all, whether the object of the legislation will be defeated or furthered. Where a specific penalty is provided in statute itself for non-compliance with the particular provisions of the Act, no discretion is left to the court to determine whether such provision is directory or mandatory. It has to be taken as mandatory. The use of the word shall with respect to one matter and the use of the word may with respect to another matter in the same section of the statute will normally lead to the conclusion that the word shall imposes an obligation, whereas word may confer a discretionary power. Case Labour Commissioner versus Burhanpur Tapti Mill. Next, rule of ageisdom generis. The term ageisdom generis means of the same kind or species. Simply stated, the rule means where any act enumerates different subjects, general words following the specific words are to be construed and are understood with reference to the words that precede them. Those general words are to be taken as applying to things of the same kind as specific words previously mentioned, unless there is something to show that a wider sense was intended. Thus, the rule of ageisdom generis means that where specific words are used, and after those specific words some general words are used, the general words would take their color from the specific words used earlier. For instance, in the expression in consequence of war, disturbance, or any other cause, the words any other cause would take color from the earlier words war, disturbance, and therefore would be limited to causes of the same kind as two named instances. Similarly, where an act permits keeping of dogs, cats, cows, buffaloes, or other animals, the expression other animals would not include wild animals like lions and tigers, but would mean only domesticated animals like horses. When there was prohibition on importation of arms, ammunition, or gunpowder of any other goods, the words any other goods were construed to referring to goods similar to arms, ammunition, or gunpowder. A versus Brown. In particular words used exhaust the whole genus or category, then the general words are to be construed as covering a larger genus. We must note, however, that a general principle of ageisdom generis applies only where the specific words are at all same nature. When they are of different categories, then the meaning of the general words following those specific words remains unaffected, and those general words then would not take the color from the earlier specific words. In the expression charges, rates, duties, and taxes, the term charges are ageisdom generis, taking color from the succeeding terms rates, duties, and taxes. Here the general category preceded the enumeration of the specific category, and so rule ageisdom generis was technically not applicable, and the court in fact applied the more general rule nocitur SOC and rightly limited the meaning to the term charges. 4.23 of CA book. Yeah, Agisdem generis. Rule applies when the statute contains an enumeration of specific words. The subject of enumeration constitutes a class or a category. That class or category is not exhausted by the enumeration. The general terms follows the enumeration, and there is no indication of a different legislative intent. It is also to be noted that the courts have a discretion whether to apply the Agisdem generis doctrine in particular case or not. For example, the just and equitable clause on the winding up powers of the court is held to be not restricted by the first 5 situations in which the court may wind up a company. Other secondary rules of interpretation. Effect of usage. Usage or practice developed under statute is indicative of the meaning recognized to its words by contemporary opinion. A uniform, notorious practice continued under the old statute and inaction of the legislature to amend the same are important factors to show that the practice so followed was based on correct understanding of the law. When the usage or practice receives judicial or legislative approval, it gains additional weight. In this connection, we have to bear in mind 2 Latin maxims. Optima legum interpres est consuetude. The custom is the best interpreter of the law, and contemporanea exposito est optima et fortissima in lege. The best way to interpret a document is to read it as it would have been read when made. Therefore, the best interpretation, construction of a statute or any other document is that which has been made by the contemporary authority. Simply stated, old statutes and documents should be interpreted as they would have been at the time when they were enacted or written. Contemporary official statements throwing light on the construction of a statute and statutory instruments made under it have been used as contemporaneous exposition to interpret not only ancient but even recent statutes in India. Example, documents issued by government simultaneously with the notification under Section 16, Clause 1 of Security Contract Regulation Act 1956 were used as contemporaneous expositio of the notification. Deshbandhu Gupta and Company versus Delhi Stock Exchange. Associated words to be understood. ये तुम्हारे पास रखो, हमारा ड्राइवर आएगा 2 बजे, वो मेन गेट पर रुकेगा, बच्चों के साथ आएगा, उनको जाकर दे देना, 2 बजे फ़ोन करेगा वो. Excludes the other. Obviously, the moral general term is used in meaning excluding the specific one. On the other hand, there is a concept of nociter a socis. It is known by its associates. That is to say, the meaning of a word is to be judged by the company it keeps. When 2 or more words which are capable of analogous or similar or parallel meaning are coupled together, they are to be understood in their cognate sense, that is akin in origin, nature or quality. They take as it were their color from each other, that is more general is restricted to a sense analogous to the less general. It is a rule wider than the rule of Agisdem generis. Rather, Agisdem generis is only an application of nociter a socis. It must be borne in mind that nociter a socis is merely a rule of construction, and it cannot prevail in cases where it is clear that the wider words have been deliberately used in order to make the scope of the defined word correspondingly wider. For example, in the expression commercial establishment means an establishment which carries on any business, trade or profession. The term profession was construed with the associated word business and trade, and it was held that a private dispensary was not within the definition. Devendra M. Surti versus State of Gujarat. The term entertainment would have a different meaning when used in the expression houses for public refreshment, resort and entertainment than its generally understood meaning theatrical, musical or similar performance. Similarly, the expression place of public resort would have one meaning when coupled with the expression roads and streets, and the same expression place of public resort would have quite different meaning when coupled with the word houses. In construing of the terms, powers, privileges, immunities of a house of the legislature of a state conferred in the Article 194 of the Constitution, the Supreme Court said that the word powers must take its color from words in immediate connection with it, and that it should be construed to refer not to legislative powers, but to powers of a house which are necessary for the conduct of its business. State of Karnataka versus Union of India. Internal aids to interpretation construction. Every enactment has its title, preamble, heading, marginal notes, definitional section, clauses, illustrations, etc. They are known as the internal aids to construction and can be of immense help in interpreting, construing the enactment or any of its parts. Internal aids are long title, preamble, heading, marginal notes, definitional sections, illustrations, provisos, explanation, schedules, and read the statute as a whole. One long title. An enactment would have what is known as a short title and a long title. The short title merely identifies the enactment, like IPC, and is chosen merely for convenience. The long title, on the other hand, describes the enactment which does not merely identify it. It is now settled that the long title of an act is a part of the act. We can therefore refer to it to ascertain the object, scope, and purpose of the act, and so is admissible as an aid to its construction. Full title of the Supreme Court Advocate Practice in High Courts Act 1951 specifies that this is an act to authorize advocates of Supreme Court to practice as of right in any High Court. So the title of a statute is an important part of the act and may be referred to for the purpose of ascertaining its general scope and of throwing light on its construction, although it cannot override the clear meaning of the enactment. Ashwini Kumar Ghosh versus Aravindo Bose. Preamble. The preamble expresses scope, object, purpose of the act more comprehensively than the long title. The preamble may recite the ground and the cause of making a statute and the evil which is sought to be remedied by it. Like the long title, the preamble of a statute is a part of enactment and can legitimately be used for construing it. However, the preamble does not override the plain provisions of the act, but if the wording of the statute gives rise to doubts as to its proper construction. For example, where the words or a phrase has more than one meaning and a doubt arises as to which of the two meanings is intended in the act, the preamble can and ought to be referred to in order to arrive at the proper construction. In short, the preamble to an act discloses the primary intention of the legislature but can only be brought in as an aid to construction if the language of the statute is not clear. However, it cannot override the provisions of enactment. Example, use of the word may in Section 5 of the Hindu Marriage Act 1955 provide that a marriage may be solemnized between two Hindus. Has been constructed to be mandatory in the sense that both parties of the marriage must be Hindus as defined in Section 2 of the Act. It was held that marriage between a Christian male and a Hindu female solemnized under the Hindu Marriage Act was void. The result was reached also having regard to the preamble of the Act, which reads, an act to amend and codify law relating to marriage among Hindus. Gullipalla Sauriya Raj versus Bandaru Pavani. Next, heading and the title of a chapter. If we glance through any act, we would generally find that a number of its sections applicable to any particular object are grouped together, sometimes in the form of chapters prefixed by heading and or title. These heading and titles prefixed to sections or groups of sections can legitimately be referred to for the purpose of construing the enactment of its parts. However, there is a conflict of opinion about the weightage to be given to them. While one section of opinion considers that a heading is to be regarded as giving the key to the interpretation of the clauses ranged under it and might be treated as preambles to the provision following it, the other section of opinion is emphatic that resort to the heading can only be taken when enacting words are ambiguous. According to this view, headings or titles prefixed to sections or group of sections may be referred to as the construction of a doubtful expression but cannot be used to restrict the plain terms of enactment. We must, however, note that the heading to one group of sections cannot be used to interpret another group of sections. Example, chapter contained in the Code of Criminal Procedure read as limitation for taking cognizance of certain offences was not held to be controlling, and it was held that a cumulative reading of various provisions in the said chapter clearly indicated that the limitation prescribed therein was only for the filing of the complaint or initiation of a prosecution, not for taking cognizance. Bharat Damodar Kale versus State of AP. Marginal notes. Although there is a difference of opinion regarding resort to marginal notes for constructing an enactment, the generally held view is that marginal notes appended to section cannot be used for construing the section. In CAT versus Ahmed Bhai, Umar Bhai and Company, the Patanjali Shastri judge had declared marginal notes is an Indian statute, as in an act of parliament, cannot be referred to for the purpose of construing the statute. Same view has been taken in many other cases. Many cases show that the reference to marginal notes may be permissible in exceptional cases for construing a section in a statute. Cases Diwan Singh versus Rajendra Pandit, Ardevi, Sarabjit Singh versus Union of India. However, marginal notes appended to articles of Constitution have been held to be part of the Constitution as passed by the Constituent Assembly and therefore have been made use of construing the articles. Article 286 of the Constitution furnishing prima facie some clue as to the meaning and purpose of the article. Bengal Immunity Company Limited versus State of Bihar. Definitional sections and interpretation clause. The legislature has the power to embody in a statute itself the definitions of its language. It is quite common to find in the statutes definitions of certain words and expressions used in the body of the statute. Where a word or a phrase is defined as having particular meaning in the enactment, it is that meaning alone which must be given to it in interpreting a section of the act, unless there be anything repugnant in the context. The court cannot ignore the statutory definition and try and extract what it considers to be the true meaning of expression independently of it. Purpose of a definition clause is twofold: to provide a key to the proper interpretation of enactment and to shorten the language of enacting party by avoiding repetition of the same words contained in the definition part every time the legislature wants to refer to the expressions contained in the definition. to provide a key to the proper interpretation of enactment and to shorten the language of the enacting part by avoiding repetition of the same words contained in definition part. Construction of definitions may be understood under following heads: 1. Restrictive and extensive definition, ambiguous definition, and definition subject to contrary context. Restrictive and extensive. The definition of a word or expression in the definition set may either be restrictive of its ordinary meaning or may be extensive of the same. When a word is defined to mean such and such, the definition is prima facie restrictive and exhaustive. We must restrict the meaning of the word to that given in the definition section. But where the word is defined to include such and such, the definition is prima facie extensive. Here the word defined is not restricted to the meaning assigned to it, but has extensive meaning which also includes the meaning assigned to it in definition section. You may also find a word being defined as means and includes such and such. Here again the definition would be exhaustive. On the other hand, if the word is defined to apply to and include, definition is understood and be extensive. Example: the usage of the word any in the definition connotes extension, for any is a word of every wide meaning and prima facie use of it excludes limitation. It has been a universally accepted principle that where an expression is defined in an act, it must be taken to have throughout the act the meaning assigned to it by the definition, unless by doing so any repugnancy is created in the subject or context. Example: inclusive definition of lease given under 216C. 2 Clause 16 subclause C of the Stamp Act has been widely construed to cover transactions for the purpose of Stamp Act, which may not amount to a lease under Section 105 of the Transfer of Property Act. State of Uttarakhand versus Harpal Singh Rawat. Section 2M of the Consumer Protection Act 1986 contains an inclusive definition of a person. It has been held to include a company, although it is not specifically named therein. Case Karnataka Power Transmission versus Ashok Iron Works. A definition section may also be worded as is deemed to include, which again is an inclusive and extensive definition, as such words are used to bring in by legal fiction and something within the word defined which according to its ordinary meaning is not included within it. For example, if A is deemed to be B, compliance with A is in law compliance with B, and contravention of A is in the law of contravention of B. Ambiguous definition. Sometimes we find that the definition section may itself be ambiguous, and so it may have to be interpreted in the light of other provisions of the Act, and having regard to the ordinary meaning of the word, such type of definition is not to be read in isolation. It must be read in context of the phrase which it defines, realizing that the function of a definition is to give accuracy and certainty to a word or a phrase which would otherwise be vague and uncertain, but not to contradict it or depose it altogether. Example: termination of service of a seasonal worker after the work was over does not amount to retrenchment as per Industrial Dispute Act. Anil Bapurao Karase versus Krishna Sahatkari Sakar Karkhana. But the termination of employment of a daily wager who is engaged in a project on completion of the project will amount to retrenchment. If the worker had not been told when employed that his employment will end on completion of the project. SM Nilajkar, Telecom District Manager versus SM Nilajkar versus Telecom District Manager. Definition subject to contrary context. When a word is defined to bear a number of inclusive meanings, the sense in which the word is used in a particular provision must be ascertained from the context of the scheme of the Act, the language of the provision, and the object intended to be served thereby. Illustrations. We would find that many, though not all, sections have illustrations appended to them. These illustrations follow the text of the section and therefore do not form part of the section. However, illustrations do form a part of the statute and are considered to be of relevance and value in construing the text of the section. However, illustrations cannot have the effect of modifying the language of the section, nor can neither curtail nor expand the ambit of the section. Example: in holding that Section 73 of the Indian Contract Act does not permit the award of interest as damages for mere detention of debt, the Privy Council rejected the argument that illustration given in the Act can be used for arriving at a contrary result. It was observed that nor can an illustration have the effect of modifying the language of the section which alone forms the enactment. In a case, Supreme Court took the aid of illustration appended or Section 43 of Transfer of Property Act for conclusion that the said provision applies to transfer of spes successionis and enables the transferee to claim the property provided other conditions of the section are satisfied. Venkatrama Iyer observed that it is not to be readily assumed that illustration to a section is repugnant to it and rejected. Juma Masjid versus Podimanindra Devaya. Proviso. The normal function of a proviso is to accept something out of the enactment or to qualify something stated in the enactment which would within its purview if the proviso were not there. The effect of the proviso is to qualify the preceding enactment which is expressed in terms which are too general. As a general rule, a proviso is added to an enactment to qualify or create an exception to what is in the enactment. Ordinarily, a proviso is not interested as stating a general rule. It is a cardinal rule of interpretation that a proviso to a particular position of a statute only embraces the field which is covered by main provision. It carves out an exception to the main provision to which it has been enacted as a proviso and to no other. Ramnarayan Sons and Sons versus Assistant Commissioner of Sale Tax. Distinction between proviso, exception and saving clause. There is said to exist difference between provisos worded as proviso, exception and saving clause. Exception is intended to restrain the enacting clause to a particular cases. Proviso is used to remove special cases from the general enactment and provide for them specially. Saving clause is used to preserve from destruction certain rights, remedies or privileges already existing. Explanation. An explanation is at times appended to a section to explain the meaning of the text. An explanation may be added to include something within the section or to exclude something from it. An explanation should normally be so read as to harmonize and clear up any ambiguity in the main section. It should not be so construed as to widen the ambit of section. In Sundaram Pillai versus Pattabhiraman, Fazal Ali gathered the following object of an explanation to a statutory provision. Explain the meaning and intendment of the act itself. Clarify any obscurity and vagueness, if any, in the main enactment to make it consistent with the object. Provide an additional support to the object of the act to make it meaningful and purposeful. Fill up the gap which is relevant to the purpose of explanation to suppress the mischief and advance the object of the act. Cannot take away statutory right. However, it would be wrong to always construe an explanation limited to the aforesaid objects. The meaning to be given to an explanation will really depend upon its terms and not on any theory of its purpose. Schedules form part of the Act, therefore they must be read together with the Act for all purposes of construction. However, expressions in the schedules cannot control the prevail over the expression in the enactment. If there appears to be any inconsistency between the schedule and enactment shall always prevail. They often contain details and forms of working out the policy underlying the sections of the statute. For example, schedules appended to Companies Act to the Constitution of India. Read the statute as a whole. It's the elementary principle that construction of a statute is to be made of all the parts taken together and not just one part only. Lord Weston, speaking with regard to the deeds, stated thus: the deed must be read as a whole in order to ascertain the true meaning of the several clauses. The words each clause should be so interpreted as to bring them into harmony with other provisions. If that interpretation does no violence to the meaning of which they are naturally susceptible, and the same approach would apply with equal force with regard to acts and rules passed by the legislature. One of the safest guides to construction of sweeping general words is to examine the other words of like support in the same enactment or insufficient or instrument to see what limitation must be imposed on them. If we find that a number of such expressions have to implicate subjected to limitation and qualification that such limitation and guidelines are of the same nature, constructions form a strong argument for subjecting the expression. For example, if one section of an act requires notice should be given, then the verbal notice would generally be sufficient. If in another section provides that the notice should be served on a person and left with him, or in a particular manner or place, that would obviously indicate a written notice was intended. External aids to interpretation, construction. Society does not function in a void. Everything done in its reasons. In background, the particular circumstances prevailing at the time and so on. These factors apply to any enactment as well. These factors are of great help in interpreting and construing an act and have been given the convenient nomenclature of external aids to interpretation. Apart from the statute itself, there are many matters which may be taken into account, and when the statute is ambiguous, these matters are also called external aids. Some of these factors are below. External aids: 1. Historical setting. 2. Consolidated statute and previous law. 3. Usage. 4. Earlier and later acts and analogous acts. 6. Definition. Next, use of foreign decisions. The history of external concurrence, circumstances, which led to the enactment in question is of much significance in construing any enactment. We have for this purpose to take up the help from all those external or historical facts which are necessary in the understanding and comprehension of the subject matter, and scope and object. Consolidating statutes and previous law. Preambles A preamble to many statutes contain expressions like an act to consolidate the previous law. In such a case, the courts may stick to the presumption that it is not intended to alter the law. This may solve doubtful points in the statute with the aid of such presumption and intention rejecting the letter. Construction. Usage. Usage is also sometimes taken into consideration in construing an act. The act done under statute provide quite often the key to the statute itself. It is well known that where the meaning of the language in a statute is doubtful, usage, how that language has been interpreted and acted upon over a long period, may determine its true meaning. It has been emphasized that when a legislative measure of doubtful meaning has for several years received an interpretation which has generally been acted upon by the public, courts should be very unwilling to change that interpretation unless they see cogent reasons for doing so. Earlier and later acts and analogous acts. Exposition of one act by language of another. The general principle is that where there are different statutes in pari materia in an analogous case, though made at different times or even expired and not referring to each other, they shall be taken with the constitution. If two acts are to be read together, then every part of the act has to be construed as if it contains one composite act. But if there are some clear discrepancy, then such discrepancy may render it necessary to hold the last point of time and notify the court discrepancy made and modified the earlier one. However, that does not mean that every word in the latest act has to be interpreted in the same way as in the earlier act. Where the latter of the two acts provides that the earliest act should, so far as is consistent, be construed as one with it. Then an enactment in the latter statute that nothing therein should include debentures was held to exclude debentures from the earlier statute as well. Where a single section of one act, Act A, is incorporated into another statute, say Act B, it must be read in the sense that which it bore in the original act from it taken consequently. It would be legitimate to refer to all rest of the Act A to ascertain what the section means. So, one section is incorporated in the new Act. Suppose the earlier bylaw limited the appointment of chairman. Supposing the earlier bylaw limited the appointment of the chairman of an organization to a person possessed of certain qualifications, and the latter bylaw authorizes the election of any person to be the chairman of the organization. In such a case, the latter bylaw would be so construed as to harmonize and not to conflict with the earlier bylaw. The expression "my person" used in cyber law would be understood to mean only any eligible person whom the requisite qualification as provided in the earlier act explained by the latter act. Not only the matter of act must be construed in the light in the earlier act, but the latter act must furnish a legislative interpretation of the earlier one. If it is pari materia and you bought only where the earlier statute contains a negative provision, but the latter one merely omits the negative provision, this cannot be itself a result of substantive affirmation. In such cases, it would be necessary to see how the law would stand where it was original provision and the terms in which the repealed sections are acted. Use of foreign decisions. Foreign decisions of countries following the same system of jurisprudence as ours and given a law similar to ours can be legitimately used for continuing our own, that is our British Commonwealth and common law practices. However, prime importance is always given to language of the Indian statute. Further, where guidance can be obtained from Indian decisions, reference to foreign decisions may become unnecessary. Rules of interpretation, construction of deeds and documents. The first and foremost point that has to be borne in mind is that one has to find out what a reasonable man who has taken care to inform himself of the surrounding circumstances of a deed or a document and of its scope and intendments would understand by the words used in the deed or document. It is inexpedient to construe the terms of one deed by reference to the terms of another. Further, it is well established that the same word cannot have two different meanings in the same document unless the context compels the adoption of such a rule. The golden rule is to ascertain the intention of the parties to the instrument after considering all the words in the document deed concerned in their ordinary natural sense. For this purpose, the relevant portions of the document have to be considered as a whole. The circumstances in which the particular words had been used would also have to be taken into account. Very often, the status and training of the parties using the words have also to be taken into account, as the same words may be used by an ordinary person in one sense and by a trained person or a specialist in quite another special sense. It is also to be considered that very many words are used in more than one sense. It may happen, same word understood in one sense will give effect to all the clauses in the deed, while taking another sense might render one or more of the clauses ineffective. In such a case, the word should be understood in the former and not the latter sense. It may also happen that there is a conflict between two or more clauses of the same document. An effort must be made to resolve the conflict by interpreting the clauses so that all clauses are given effect to. If, however, it is not possible to give effect to all of them, then it is the earlier clause that will override the latter one. Similarly, if one part of the document is in conflict with another part, an attempt should always be made to read the two parts of the document harmoniously, if possible. If that is not possible, then the earlier part will prevail over the latter one, which should therefore be disregarded. Summary: enacted laws and rules are drafted by legal experts, and so it is expected that the language used will leave little room for interpretation, or construction of statutes. Helps in finding out the meaning of the ambiguous words and expressions given in the statutes and resolving inconsistency lying therein. If any provision of the statute is open to two interpretations, the court has to choose that interpretation which represents the true intention of the legislature. The best interpretation of statute is possible by adoption of various guiding rules of construction and aids to construction of the statutes. The courts are the best interpreters. They strongly lean against a construction which reduces the statute to a futility. A statute or any enacting provision therein must be so construed as to make it effective and operative, and the principle expressed in the maxim ut res magis valeat quam pariat. Multiple choice. Formal legal document which creates or confirms the right or record the fact is a document, deed. Which among the following is the cardinal rule of construction of statutes? Harmonious, beneficial, literal, reasonable. Literal. Rules of reasonable construction is based on the maximum contemporanea expositio. Rules of beneficial construction is also known as mischief rule. Pick the odd one out from the following aids: preamble, marginal notes, proviso, usage. Preamble. Which rule of the construction is applicable where there is a real and not merely apparent conflict between the provisions of an act? One of them has not been made subject to the other. An internal aid that may be added to include something within the section or to exclude something from it. Is a proviso. An aid that expresses the scope, object and purpose of the act. Preamble. Explain the rule of beneficial construction while interpreting the statutes, quoting an example. Answer. Where language used in a statute is capable of more than one interpretation, the most firmly established rule for construction is the principle laid down in the Hayden's case. This rule enables consideration of four matters in constituting Act 1. What was the law before making of the Act? What was the mindset of the defect for which law did not provide? What is the remedy the Act has provided for? And what is the reason for the remedy? The rule then directs that the courts must adopt a construction which shall suppress the mischief and advance the remedy. Therefore, even in a case where the usual meaning of a language happens to fall short of the whole object of the legislature, a more extended meaning may be attributed to the words provided they are fairly susceptible of it. If the object of any language is public safety, then its working must be interpreted wisely to give effect to that object. Thus, in case of Workmen Compensation Act, the main object being the provision of compensation to workmen, it was held that the Act ought to be so construed as far as possible so as to give effect to its primary provisions. However, it has been emphasized by the Supreme Court that the rule in Hayden's case is applicable only when the words are used are ambiguous and are reasonably capable of more than one meaning. CH versus Sodradevi, question 2. Explanation of the words of grammatical interpretation and principles of grammatical interpretation and logical interpretation. In order to ascertain the meaning of any law and statute, the principles of grammatical and logical interpretation is applied to conclude the real meaning of the law and the intention of legislature before enacting it. Meaning, grammatical interpretation the court cannot delete or add, modify a letter of law. However, when a letter of law is logically defective on account of ambiguity, inconsistency or incomplete, the court is under a duty to travel beyond the letter of law so as to determine the real intentions of the legislature. So that a statute is enforceable at law, however unreasonable it may be. The duty of the court is to administer Duty of the court is to administer the law as it stands rather than just it is just and unreasonable. However, if there are two possible constructions of a clause, courts may prefer the logical construction which emerges from settling, in which the clause appears under circumstances in which it can be enacted. Also, the words. Question 3. What is the effect of proviso? Does it qualify main provisions of the enactment? Does an explanation add to a section within the wide ambit of a clause? And normally, a proviso is added to a section of an act or to accept something or qualify something stated in the particular section to which it is added. A proviso should not be ordinarily interpreted as a general rule. A proviso to a particular section carves out an exception to the main provision in which it has been enacted as a proviso and to no other provision. Ramnaran Sons versus Commission of Sale Tax. Sometimes an explanation is added to a section of the Act for the purpose of explaining the main provisions contained in that section. If there is some ambiguity in the provisions of main action, explanation is inserted into harmonize and clear up ambiguity. Into something may be added to be maybe to, or something may be excluded from the main provision of the Institution Act of an explanation, but the explanation should not be construed to widen the ambit of the section. Garo Textile Company Limited has entered into a contract with a company. You are invited to read and interpret the document of contract. What rules of interpretation of deeds and documents will you apply while doing so? Rules regarding interpretation of deeds and documents are as follows. First and foremost point, it has to be borne in mind that has to find out what reasonable man can, or who has to take care of and inform himself of the surrounding circumstances of a deed or a document and of its scope and would understand by the words used in that deed or document. It is expedient to construe the terms of one deed by reference to terms of another. Further, it is well established that the same word cannot have two different meanings in the same document unless the context compels the adoption of the rule. The golden rule is to ascertain the intention of the parties of the instrument after considering all the words and documents concerned to their ordinary natural sense. For this purpose, the relevant portion of the document have to be considered as a whole. Circumstances in which particular words have been used have also been taken into account. Very often, statute training of the parties used in words have also to be taken into account as same words. Specialist may be used in an ordinary version and in one sense and by a trained person, or by a specialist in guitar, another sense or special sense. It is also to be considered that very many words are used in more than one sense. It may happen that the same word can be understood by, in one sense, differently by different persons, by rendering one or more of the clauses ineffective. In such a case, the word should be understood in the former, but not in the latter of the case. It may also happen that there is a conflict between two or more clauses also. An effect may be made to resolve the conflict by interpreting the clauses so that all. How will you interpret the definition in a statute? If the following words are used in statute, means and includes, gives one illustration of each of the above found, including the interpretation of the words means and includes is the definition. The definition of a word or expression in the definition section may either be restricting to its ordinary meaning or may be extensive of the same. When a word is defined to mean such and such, the definition is prima facie restrictive and exhaustive. You must restrict the meaning of the word to that given in the definitive section. But where does the nod is definitely include and such and such, and the definition is prima facie extensive. Remember, definition of director, section 2, clause 34 of the Companies Act. Director means a director appointed by the board by a company. The word means such exhaustive definition. Definition of a whole-time director, section 2, clause 94 of Companies Act. Whole-time director includes a director in the whole-time employment of the company. The word includes extensive definition. Other directors may also be included in the category of the whole-time director. Question 6. Differentiate between mandatory. Answer. Practically speaking, the distinction between the proviso which is mandatory and that is non-mandatory is that whenever it is mandatory, it must be strictly observed. When it is right, it will be sufficient and it deserves. Practically speaking, a distinction between a provision which is mandatory and one which is directory is that when it is mandatory, it must be strictly observed. When it is directory, it would be sufficient if it is substantially complied with. However, we have to look into the substance and not merely the form. An excellent in mandatory form might substantially be directory, and conversely, a statute in directory form may in substance of mandatory. Hence, it is the substance that counts and must take precedence over the mere form. If a provision gives power coupled with a duty, it is mandatory. Whether it is not so would depend on such consideration. As nature of doing, about object for which it is done, the person whose benefit the power is to exercise. Divine grammatical interpretation. What are the exceptions to grammatical interpretation? Grammatical interpretation and its exception. Grammatical interpretation concerns itself exclusively with verbal expression of the law. It does not go beyond the letter of the law. In all other cases, grammatical interpretation is the sole form allowable. The court cannot take the from or add to modify the letter of law. Rule, however, is subject to extreme. Letter of the law is logically defective on account of ambiguity, inconsistency, or incompleteness. As regards defective ambiguity, the court, in the case of statutory expression being defective on account of inconsistency, court must extend the spirit of the law. If the text leads to a result which is so unreasonable that it is self-evident that the legislature could not mean what it says, the court may resolve such impasse by inferring logically the intention of jurisprudence. Intention of the legislature. Question 8. Write short notes on provision explanation. Rules for interpretation of statutes. The normal function of the state. The normal function of a provision is to accept something out of the enactment or to qualify something stated in the enactment which would have within its purview if the proviso or not there. The effect of proviso is to qualify the preceding enactment which is expressed in terms of which are too general. As general rule, a proviso is expressed in terms the two qualify or as a general rule, a proviso is added to the enactment to qualify or create an exception to what is in the enactment. Ordinarily, a proviso is not interpreted as stating a general rule. It is a cardinal rule of interpretation that the proviso to a particular measure of a statute only embraces the field which is covered by the main provision. Explanation. The explanation is at times dependent to a section or explanation of the text of section. Explanation may be added to a rule. An explanation should normally be said to read to harmonize with and gap. An explanation is at times appended to a section and explain the meaning of the text of the section. An explanation may be added to include something within the section or exclude something from it. An explanation should normally be read so as to harmonize with the clear up any ambiguity of the main section. It should not be so construed as to widen the ambit of the section. Meaning is to be given to application, not to any theory or its purpose. Question 9. Explain mischief rule for interpretation of statute. Also give 4 matters considered in construing an act. When a percentage language is used in a statute, it is capable of more than one interpretation. Principle laid down in the Hayden's case is followed. This is known as purposive construction of a voucher mischief rule. Suppresses then adds it has been emphasized the Supreme Court that the rule in the Hayden's case is applicable only when the words used are ambiguous and are reasonably capable of more than one meaning. Enables consideration of 4 matters. What was the law before the making of the act? What is the Messiah? What is the remedy in short under CPC? What is the reason for remedy? Tenth question. Explain how dictionary definitions can be of great help in interpreting, constructing an act when the statute is unambiguous. Dictionary definitions. First, we refer the act in question to find out if any particular word or preposition is defined. Where we find that a word is not defined in the act itself, we may refer to dictionaries to find out the general sense. However, in selecting one of the several meanings of a word, we must always take into consideration the context in which it is used. It is the fundamental rule that meaning of the words and expressions used in an account must take their cohort from the meanings of words and expressions must take their color from the context in which they appear. Further, judicial decisions laying down the meaning of words and construct in statute in pari materia will have greater impact than the meaning contained by dictionaries. However, technical terms of reference may be made to technical dictionaries.